Welcome back, everyone. Well, as businesses continue to face the most testing period in modern memory, they are also having to grapple with a number of legal challenges as well. This next session explores the most pressing legal issues facing the industry right now.
Thank you to all three of you for joining us here today. I'm just going to introduce the three of you. We have Simon Bunce, Head of Legal Services at Abta, Joanna Chatterton, Partner and Head of the Employment and HR team at Fox Williams, and Joanna, Director at Themis. Do I say Themis or Themis?
Themis, yeah.
And so we've got two Joes. I'll refer to Joanna as Joe K and Joe C for Joanna Chatterton. Because all three of you cover various different parts of the sector, I thought it might be interesting for each of you just to offer a 5-minute update on the key areas within your sector. So Joe Chatterton, if you could just give us a key update on employment law. Simon, if you could give us an update or lack of on PTRs and where we're at with that. Okay, if you could just talk to us a little bit about the ongoing controversial topic of refunds. Joe C, should we start with you?
Sure, yeah, absolutely. So I think the travel industry had perhaps a little bit of a head start on many sectors in preparing itself for the full impact of COVID-19 on its employees and its human resources, because it was facing curtailed business travel and holiday travel cancellations before there was talk of a lockdown. And the employment law challenges it's faced, and I think the steps that the businesses in the sector have taken to manage staffing costs and resourcing were initially around redundancies and unpaid leave, reduced pay, or whether that's with or without a proportionate reduction in working hours, and generally pay cuts and bonus freezes. But then, of course, we had the furlough scheme once the coronavirus job retention scheme was introduced. So a lot of focus has been on furloughing staff and perhaps bringing people back from redundancy to put them on furlough. In terms of the particular legal issues, one of the things I think everybody is grappling with is that if you want to put in place pay reductions, hour reductions, or actually even ask employees to go on furlough, you need their express agreement unless your contract allows, and most contracts don't allow that. And in normal circumstances, that might entail a consultation with employees. And certainly if you were intending to make over 20 redundancies, if employees don't agree to the changes, then that consultation may need to be conducted on a collective basis. But many businesses have simply needed to make the changes quickly to preserve cash flow and save costs. So, in most cases, I think we're finding, in the travel sector and outside the travel sector, that employees have accepted the changes, perhaps as a better alternative to having no job at all. But there is the possibility that they could challenge them if they've been imposed without agreement. And there are various routes that they could do that by, although you can probably breathe a little bit easier after you've gone through a few payrolls on reduced pay arrangements, for example. Okay. Some early adopters of furlough may not have got the written agreement of their furloughed employees, and the latest guidance from HMRC suggests that that's required, although that hasn't been in any previous guidance. Fortunately, though, when you go on to the HMRC portal, there's no question about whether there is a written agreement in place, and you might not want to ask people at this stage whether they agree, because that could give rise to more, concerns, questions, etc. Yeah. On the furlough scheme, I think a particular frustration across the piece has been that the furlough rules were developed piecemeal. So employers are furloughed, somewhat second-guessing the exact rules. And that has in some cases resulted in people delaying furlough in the hope that they'll get more clarity, but that has obviously resulted in a cost to the business. So one good example of that has been holidays and whether they could be taken during furlough and what you had to pay people. Mm-hmm. And that was finally answered actually in a tweet from HMRC rather than any formal guidance. So it's not really been an ideal situation, but this is a new scheme and it's being worked out. I think the other big area where we've seen a lot of inquiries from travel companies and businesses is because they have international workforces. So colleagues who specialise in immigration law have had many questions about the impact both on those in the UK who are subject to immigration control and those who are due to come here to work. All of the visa application centres in the UK and overseas are now closed for application until further notice. So individuals are unable to complete visa applications, and they might find themselves in danger of overstaying or breaching the conditions of their leave to stay in the UK. And obviously that has potentially very serious consequences. So the Home Office is trying to address some concerns with some temporary measures, which includes allowing those whose leave expires permission to stay till the 31st of May, switching from short to long-term visas will now be allowed in country for the time being, and some employees might be able to start work under the points-based system before their application's actually been improved.
Okay.
I think the other thing is obviously that we're dealing with a lot from an employer's employment law perspective of the legal and practical issues around managing a remote workforce. So some clients are very worried about productivity and managing that, particularly because some people have caring demands, homeschooling children, etc. Disciplining those who can't be as productive or work their normal hours could give rise to potential discrimination issues. For example, if women are predominantly bearing the brunt of childcare and homeschooling. Maintaining confidentiality and protecting client and other data, particularly where there are flat and house shares with other people who are working in different companies, has been a real headache and potentially obviously significant commercial risks, but could lead to complaints to the ICO about data protection. And obviously health and safety is a huge one because it's simply impossible to carry out workstation assessments. Many small businesses can't afford to supply equipment. I don't know if you were like me when the lockdown was coming in, there are a whole load of people on my tube going home carrying screens with them from their offices. And I do know people are trekking back into offices to get chairs and this kind of stuff. But it's also about the sort of mental well-being of teams. And how you can support that. I think the other thing that we're now turning to is what does it look like coming out of lockdown and what are the legal issues there? And I think there's a considerable challenge in opening up workplaces, and how do you do that in a safe manner and persuade everyone that it's safe to come back? So we're being asked questions around whether employers can require testing, whether they can require face masks to be worn, what about distancing arrangements, what can they ask people about their health conditions, have they have COVID-19, etc. So lots of issues there. And I suppose just finally, our expectation will be in the travel industry that once the furlough scheme ends, many businesses are going to have to re-engage in thinking about restructuring and redundancies, because normal levels of business are going to take quite a bit of time to come back on stream. And that's not, of course, being helped by statements by the likes of Grant Shapps, for example, saying, nobody should be booking their summer holidays yet for the foreseeable future.
I mean, that's an interesting point to end on, Joanna, because it's the government's lack of inaction and not exactly being particularly supportive of the industry that has given us a lot of frustrations. Simon, that leads in quite nicely to you. Can we just have an update from you, or a lack of, with where we're at with the package travel regulations? I feel like we've been on tenterhooks waiting for an update for perhaps 4 weeks. I think we finally hoped that the government coming back on Tuesday might perhaps instigate some final, conversations on this, but nothing's forthcoming. Is that right? Or?
No, I mean, it has been, I have to say, one of the most frustrating episodes of my career, just trying to work with the government, with the officials, to get some movement on this. I think what's fascinating. We saw the Which report this morning. There's a lot of coverage this morning. We've seen the sort of comments by others in the industry, like Payne Piri. Actually everybody is kind of agreeing that the 14-day period in the package travel regulations is not working at the moment, and therefore it needs to change. There's discussion around the time period that should be introduced to allow refunds to be paid, but nobody's arguing with the basic principle. And I think that's what's so frustrating with our discussions with the government, is that even though there seems to be a general acceptance that provision in the package travel regulations isn't going to work at the moment for all sorts of practical reasons, there still isn't any movement from the government or any support from the government to recognise that fact and to give some consumer confidence around the the position that even if they don't get their refund in 14 days, those monies are protected and they don't need to worry about it, and at some point in the future they will get their money. So it is incredibly frustrating. We are, on a daily basis in contact with the officials particularly, but also at a political level as well, and that is ongoing. We saw, there was the announcement at the weekend, or the leak at the weekend, which hit the press. Don't know where that came from, not entirely sure what that was all about.
The 4 billion bailout suggestion.
The 4 billion pound bailout. I mean, we've gone back very strongly on that because the wording of that, wherever that came from, the wording was particularly unhelpful, because if the message gets out to the customers that the travel industry is being given £4 billion by the government, that just increases the demands for them to be paid their refunds. So, we've gone back very strongly to stress that, that sort of language is really not helpful. Plus, as you say, the seemingly off-the-cuff comments from grant chats about not booking summer holidays. I mean, there is absolutely no reason why people can't carry on planning their holidays. If they pay money over, it will be protected. If the holiday doesn't go ahead, they will get a refund. So there's no reason not to have confidence that those things will still operate. So, very, very frustrating. So no update on that, I'm afraid. A few things I did want to pick up on. And one is hopefully not cutting across what Joe Kay is going to say, but on the part of the refund point is, of course, a large part of the problem with giving refunds is the fact that the monies are still with the suppliers and the airlines. And the tour operators aren't getting those monies back in a timely fashion from the airlines. Now, of course, we know the airline position, Regulation 261, they are required to give these refunds, and they're not doing that. So again, we've certainly been making lots of representations to the CAA, which is the enforcement body and the regulator in the UK, 261. And I would certainly encourage all travel companies who are encountering difficulties with the airlines to continue doing that. The other bit is the other suppliers in other countries, and we've seen, and this is part of our submissions to the government as well, we've seen an awful lot of activity in other countries where their governments are taking action to allow their traders to give refunds by way of voucher or to give delayed refunds. Exactly the sort of activity that we're not seeing in the UK. Now, the difficulty with those laws as they're coming in is that in a number of countries, they're also catching the refunds due to tour operators. So although the fully support, and it would come chimes with our position on refunds to direct clients, but what we're saying with these countries is that those laws should not affect the normal commercial contractual relationship between the tour operators and the hotels, for example. Because again, that means that our tour operators aren't getting the refunds back from their suppliers overseas. So certainly in Greece, that's a problem, as I understand it, and in Italy. In France, the law only applies to direct consumer contracts, so tour operators should still be insisting on refunds under their normal contractual terms with French hotels, and similarly in Spain. The last thing I wanted to mention, which is sort of looking forward a bit, which I think the lawyers and the government are going to have to grapple with, is the situation around the FCO advice as we see different countries across the world start to open up again. So as we see in various countries across Europe, their lockdowns are being slightly eased at the moment. And you can imagine that continuing as we go through the summer. And I think there's a real challenge there for the government and for the FCO as to how they manage the ability of UK travellers to go on holiday where a nation country might be open, might be accepting visitors, but we might still be in a more sort of stringent lockdown position. And I think as we came into this situation, we had real problems with this because the FCO and the government didn't do what they normally do. It wasn't a case of them advising against travel to a particular destination. We saw the destinations themselves close down, but the FCO not advising against travel. We also saw the FCO or the government advising over 70s, so a specific part of the population, which they don't normally do. And we saw them give time-bound advice as well, which they don't normally do. So we had all sorts of difficulties coming in, and how do those different situations apply under the regulation? And I think as we come out of this over the summer, I think we're going to see a sort of mirror effect where there's going to be a real challenge for the government and the FCO to get that right, so that travel companies and their customers understand, what the rights and obligations are of both sides. So that's sort of looking ahead. I mean, I might be being slightly optimistic that this is all going to happen over the summer. But looking ahead, I think that's something that we all need to start thinking about, and certainly the government and the FCO. We are in close contact with the FCO on all of these things.
Right.
That's something we need to be mindful of as we come through this in the longer term.
So you are in dialogue with the FCO about issues like this? Well,
we're in dialogue with the FCO, constantly about their advice and different situations. The one thing we never do with the FCO is try and lobby them as to what that advice should be, because they are the experts in this. They have far more sort of intelligence and information that we're able to have. So they are the right people to make those decisions. But just making them aware of the sort of impact of those decisions and how they might play out, and the sorts of things they need to take into consideration is certainly something we feed into the FCO.
Yeah. Joe, obviously Simon mentioned it, and the PTRs are obviously intrinsically linked to this refund issue. It's something that I know you feel particularly passionate about, and you wrote an excellent piece at LinkedIn, which you've got on TTG, and you got a comment about. But this is a really big issue, and your clients are feeling it really strongly, isn't it? Talk to us a little bit about the issues that you're seeing.
Absolutely. Yeah, it's a difficult one, and I have to say, Abta are doing an absolutely stellar job, and I'm not just saying that because Simon's here, but they're actually doing a stellar job of trying to give the industry some guidance, and it really is the only guidance we have at the moment. So, as Simon said, we are still waiting to find out if the government's going to help us and relax the PTR rules, change PTRs, so that we can get through this next period while we're dealing with the COVID pandemic. But in the absence of a change to the law, Abta have given some really useful guidance about how you can give customers some confidence that if they choose to book at a later date because they don't know when they might be able to book, or they choose to take a refund, either way, the right to a refund remains. It absolutely remains. No one's trying to take that away from anybody. But at the same time, you can issue this refund credit note pending processing of that refund or booking your arrangements. As long as you are clear with the consumer, you can't force them to take it, and their right to a refund remains. But this is what everybody's grappling with. And the problem that we're seeing, and certainly I'm seeing, is I've got lots of clients that are doing it the right way. And then there are a few people that are unfortunately not following that guidance, still refusing refunds or not talking to customers, which is where we're seeing a lot of the problems, actually. And even then, we've got some customers that are going down the chargeback route just because they're afraid that the refund credit note isn't protected because they're not getting the clarity that they need. So there's all sorts of things going on. But I do think that right now the best thing everybody can do is absolutely follow the Abta guidance. I mean, whether or not you're an Abta member, and I've had this conversation with Abta separately and on other forums like this, is they're saying, look, this is not a time for people to, seek to form different camps, really. They just need to follow a line, and it's an industry line, and I think we will accept it's a very reasonable one. We don't want consumers to lose confidence in the sector. And if everybody follows this guidance, and I can't understand why people aren't, to be honest with you, where they're not, it's just a lot easier. We are so much stronger together if we all follow this model. They've made it so easy. They've given you a template to follow on the refund credit note that absolutely provides the customer with all the confidence they need in order to know that their money is protected. That has to be the underlying message, knowing that some people will be losing their jobs, they may not feel ready to make those decisions, they may just want their money back, and that money, you know, has to rightfully be given back to them if they insist on it. But all we're asking for is a bit of time while we process all of this through the system, because as Simon said, there's suppliers that aren't paying back at the moment. The airlines are grappling with their own issues, not dissimilar to those in the package market in a way, because they've got their own supplier issues the same way we have on the travel side, on the package travel side. But what we're trying to do is achieve a collaborative effort. And then in the background, Abta is also lobbying hard to make sure that the government does try and help us with the relaxation of the rules, so that that backs all of this up from a legal perspective as well.
But it doesn't help with the reports, like you said, about with Which kind of coming out, accusing firms of breaking the law. And, you know, they're not breaking the law if they're still committing to refund. Those companies that are saying we're not going to refund are breaking the law. But all Abta is asking for, and most of the industry is asking for, is a little bit more time to process these refunds. And yeah, I can see the frustration.
I mean, can I just say, I mean, those companies that are refusing to refund are doing some real damage to the rest of the industry. You know, that's never been our position. Our position has always been that the customer is entitled to a refund if that holiday is not going ahead. And there are, you know, the vast majority of companies in the industry are managing this in a really good way as best they can. Very difficult circumstances. I mean, you know, the furlough worker scheme doesn't help, because, you know, if you've got the workers who are furloughed, they can't then come back and process the refunds for you. So, you know, there's all sorts of issues there. So the vast majority of companies are doing a really good job under most appalling conditions. There are a handful of companies out there who are getting the press, who are refusing to give refunds. We are in touch with a number of companies who are Abta members, and we will take action under the Code of Conduct.
What kind of action, Simon? Would you revoke membership?
Well, we could do. I mean, the problem is with the Code of Conduct, it's not the problem, it's the way that it works. There is a process to go through. So, you know, we will need to take these companies through that process, and at the end of that day, you know, companies could end up having their membership terminated. You know, we sincerely hope we don't get there. And the way that we always work under the Code of Conduct is that you enter into a debate, into a conversation with the member. You try and explain to them what the right thing to do is, and hopefully they come with you. And by and large, that's what's happening. But at the end of the day, as I say, I think these companies are doing real damage, not just to themselves, but to the reputation of the industry, and that's not right.
And it's hard to win back that reputational. You know, it takes years to win a good reputation. It can be destroyed so quickly. And
And I have to say, sorry, I was just going to say, I think the businesses that I'm working with that are proactively contacting their customers, working, you know, around the clock to make sure that they're communicating that information, are actually having really great success with moving bookings. You know, actually 2021 in some cases looks fantastic for them, just because they've given those customers that reassurance, and the customers are happy to take that reassurance because they're really giving them all of those tools that they need to make that decision. And I think, as Simon says, if we don't deal with it properly, that those few bad apples are going to spoil the cart for everybody. And we are going to end up with, I think, a harder form of regulation and enforcement. And then the good that everyone is trying to do by forming a party line, giving that, you know, confidence and that comfort that the consumers need in order to make those decisions or take the refund credit notes, will all just disappear, and it will be for nothing, because we just won't be able to, you know, pull everybody together in a cohesive way to drive that message forward. So I think communication is the key, because if we don't communicate, even outside of the law, park the law for 1 second, that obligation, that human side to deal with your customers, if you don't deal with it in the right way, you're going to lose them all anyway. And the reputational impact that our industry is going to take is going to be a lot harder to recover from.
The challenge is as you said, is communication is paramount here. But if you don't have the staff to have that communication, that's where the real challenge lies. Josie, I mean, the furlough scheme has been fantastic in giving some much needed money to businesses, but travel is so unique in that it needs those staff there to help those clients. Is there an inkling or suggestion that the government might be more sympathetic to the unique needs of the travel industry and perhaps create some kind of leeway with the furlough scheme, or is there anything like that we might see? Or
not that I've seen. None of the comments coming out are other than, you know, when someone's on furlough, they must not be working. They can do voluntary stuff, they can do training, but what they can't do is work. And of course, there is a minimum period of 3 weeks, so it doesn't give a lot of flexibility. That, you know, the situation where you might have a bit of a downturn, then you have a tick up because you need people to come in and process refunds or whatever it is. So I don't think, I strongly suspect that they won't relax the flexibility on that. And that leaves employers with the difficulty of thinking, well, you know, instead of doing furlough, I've got then, because of my cost base, and I've got to then think about hours and pay cuts for people. And actually, I've had clients with situations where, you know, they're asking people to take a 50% pay cut. They're only working 50% of the time, but they're not going to get as much as some of the people who are on furlough.
yeah,
If they're lower paid employees, and that's nonsensical. I mean, how do you sell that to people? So the only way that they're addressing that is to do sort of rotating furloughs. So somebody might be on furlough for 3 weeks, they'll then come back for a week or two or even 3 while somebody else goes on furlough. So you effectively sort of spread the pain, as it were.
and can you do that? Can you bring someone off furlough then back and then
Yes. Yes, you can, as long as you do it in 3 week slots. So you've got to have a minimum 3 weeks with someone on furlough. That's proving a bit problematic anecdotally when people have logged on to the portal, because people are having trouble putting in arrangements where somebody's on furlough then off, or going on furlough at a later date. So I don't know if that's been ironed out at the moment, but a lot of feedback from clients yesterday and on Monday was that trying to put in those arrangements into the portal to claim the grant was proving problematic.
Okay, so it might be a bit of an admin headache, but it could be a short-term solution perhaps for some travel businesses that are suffering in that respect. I am conscious of time, so just before we wrap this up, I do just want to talk about the issue of chargebacks, because I know that that's a point that agents have been getting increasingly frustrated by, where they're being stung in effect by chargebacks, when actually it should be a burden that's also shared by suppliers as well, or is solely shared by suppliers. Simon, are you seeing this as quite a big concern for agents?
Yes, and I think you know, that's another reason why we really do want the CAA and the government to come out and give some confidence to customers around the sort of concept of the refund credit note, because I think, you know, what the refund credit note does is, as I sort of said earlier, it gives the customer the protection, everything's fine, it just sort of delays things a little bit. And I think part of the reason that, you know, customers will push for a chargeback is because they think, well, you know, this is just something that Abta's come up with, and I don't really trust any of that. I'm going to charge back. So I think, you know, if the government and the CAA would come out and say something, I think that would really help there. Yeah. Because again, I think from the timing point of view, this could only get worse otherwise. You know, we're coming into, you know, as the season goes on, there will be more cancellations. Yeah. Therefore, more customers involved in all of this, and you will see more chargebacks or attempted chargebacks. So, you know, it's the situation is only going to escalate. I mean, I think the advice, and Joe Kane can probably come in here as well, you know, is to challenge them. You know, particularly if you are an agent. You know, if you're an agent, then there shouldn't be a chargeback under Section 75, certainly. So there are defences to these, and in any event, challenging it does delay to a certain extent the sort of paying out of the monies. So, you know, for a lot of people, that is the problem. It is that timing of the cash flow.
And if these
so challenging is, I think, you should certainly challenge it.
If these tour operators aren't paying out, if they are Abta members, presumably agent members can contact Abta as well and report them against the code of conduct, because agency agreements stipulate that suppliers need to carry the cost for that.
Well, if the tour operators are not paying refunds, then yeah, that's certainly something that we would pick up under the code of conduct. Delaying the refund, of course, is exactly what we're all trying to do.
Yeah.
So our line on that is that we're not saying that those refunds have to be paid within 14 days. We're saying they have to be paid without undue delay, which is the wording that's always been in the code of conduct. That's what's underpinned our position all along. And that is going to vary according to company. But it goes then back to the communication points that Joe was saying. If the customer knows that you're working on a 30-day refund process, a 40-day, 60-day refund process, whatever it is, if the customer knows that, then the customer can sort of sit back, rest assured that money will come through eventually. If you just ignore your customers, they've got no idea if they're going to get their money back, they will charge back. So, I think that communication is absolutely key to all of this, which then, of course, gets us back to the furlough problem. Have you got the staff there to do the communication?
Yeah, it's that vicious cycle.
Absolutely, yeah.
I am conscious of time, so I do want to cut now to questions. But thank you very much to all of you for your time now, and we're just going to move to questions.
Hi everyone, hope you all found that session useful. We are now bringing in our three panelists to move to the live Q&A. I've seen quite a few questions come through. Do please keep them coming through. Some really valuable advice from all of them, whether it's on the employment side of things from Joanna Chatterton with advice on the furlough scheme, or on PTRs, or on the refund credit notes, which of course is creating a lot of controversy at the moment. If you just post your question in the Q&A box down the bottom, then I'll try and get through as many as I possibly can. I can see Joe K has joined us. I think Simon's joined us. Joanna Chatterton will be shortly. We do have quite a number of questions coming in through about refunds, I noticed. So I know that will probably be the hot topic of debate. Welcome, Joe Kolatsis, Simon, and I know Joe Chatterton should be joining us very shortly. You can see she's joined, her face will be joining us soon. Welcome, there she is. Hi all, thanks so much for joining us here. Understandably, we've got quite a few questions coming in through just about refund notes. Someone has directed this at Joe K, although I wonder if Simon can help. They say, how would Joe advise we respond to the occasional client who's refusing a refund credit note? Nice they say occasional, it's clearly not the majority for them. They're insisting instead only on a cash refund and saying that we are blatantly breaking the law if it's not refunded in 14 days. Do they have legal recourse?
Right, so I think let's just re-emphasise the point that we made right at the beginning, which is the right of refund remains. We can't force people to take refund credit notes, but if you can persuade them to hold on to that refund credit note while you're processing that refund, then that should be okay. But yes, we've got to remember that there has not been a change in the law up to now. What we're trying to do is just get everybody comfortable with the fact that we need a bit more time to process them. So it just goes back to that point about stay in touch with them, perhaps tell them where you're at roughly in terms of processing refunds and dates that you're working towards. Some people are working on a departure date basis. I think as long as you're communicating those timeframes, that might help them to understand that what you're not doing is refusing that refund. You're just trying to give them something that they can hold on to that confirms that whatever happens, they are financially protected while you're running through that process. I don't know if Simon wants to jump in as well.
Yes, well, as Joe says, as we said all along, that customer has the legal right to a refund. They have a legal right to a refund within 14 days. In practical terms, that's highly unlikely to happen at the moment. I think again, it is down to that communication with the customer to have that conversation with them, explain when they will expect to get that refund from you. But I think as well, explain to them, yes, of course they can take legal action against you if they want to recover that refund. But that legal action is highly likely to take far longer than the refund process is going to take anyway. So they would be sort of embarking on something which is unnecessary, because the tour operator will give them the refund. They just need to be patient and wait for them to get it through their system.
Yeah.
So yeah, it's back to the same thing. That legal right is there for customers. What we're trying to do is to manage that in a sensible way, while tour operators get themselves in a position to process all the refunds. But as you said, it's very, very encouraging to hear that it's the occasional customer who is pushing for the refund, and you know, it's very difficult to tell across the piece how customers are responding to the idea of a refund credit note. I mean, clearly there's a lot of noise on social media about it, but whether that is reflective of the travel customer as a whole, it's really difficult to get a sort of handle on that.
It's the angry people that tend to shout louder, isn't it? So
Absolutely,
perhaps they're a minority.
Yeah.
Of course, the challenge, we said communication is king here. The challenge, of course, for travel is that many people have obviously had to furlough their staff. Joe C, you raised quite an interesting point that businesses can actually furlough staff for 3 weeks, bring them back in and furlough them again. I don't know if that's a point that maybe many in the industry would perhaps have realised. Do you think it's something that many businesses will employ, and perhaps there needs to be wider awareness about it?
Yeah, I think I've certainly got a number of clients who are doing that very thing, so that they're trying to sort of spread the pain between employees. So, they will have, as long as they have sort of minimum 3-week periods, they can put people on for 3 weeks, then off for 3 weeks. And I think that's been quite a common response. As I was saying, that can be a bit problematic, claiming on the system, but hopefully that will be ironed out over time. Certainly in the next few days, to make that a bit easier. But there's no reason why under the scheme you can't do that.
Daniel Bainbridge, actually, just on that furlough point, he has a question for you, Josie. He says, can you clarify if an organisation is able to rotate or alternate furloughed between two workers with identical roles, as in 1 month on, 1 month off?
Yeah, no problem with that at all. A month is fine as long as it's at least 3 weeks. You can just swap them over. Yeah.
Okay, great. Hopefully that helps. Simon, they want a bit more information, or just, we did sort of address this, but they're asking, how is Abta going to address those operators that are not adhering to their guidance on refunds? I know you did address that. You are examining those who are failing to adhere to the code of conduct.
Yes, and this is what my teams are actively working on as we speak. There's a range, of course. There are the companies that are point blank refusing to give refunds, and that is, it's in breach of the law, it's in breach of the code. So we are in touch with those, and as I said in my piece earlier, those discussions are happening, and we are explaining their responsibilities, and by and large we are seeing them change their policies, so that's good. If we have any that refuse to do that, then of course, as I said, that will go through the process, and that will end up with the Code of Conduct Committee, and the relevant sort of sanctions will be imposed, which may result in termination of membership. I sincerely hope we don't need to get there with any of the members. But as I say, it is a range. So there is, there are companies out there whose refund credit notes don't entirely fit with what we would expect. And again, we will have conversations with them and try and get them to sort of remedy that. I think the issue that people are really struggling with is the time period for paying refunds. So if the if the customer is prepared to accept a refund credit note, or even if they're not, then our rule under the code is that the refunds must be paid without undue delay. Now that's a beautifully vague legal phrase, and that's the one I think that we're having problems with in getting people to come up with a clear and reasonable plan for paying those refunds, because that will depend on by company by company. There are companies who really cannot, for operational reasons, make those payments, any time in the next sort of 3-4 months or whatever. They aren't getting the monies in from their suppliers. They've got staff that are, being laid off or furloughed. So for operational reasons, they are just not able to get those refunds out any quicker.
Yeah.
Now, is that without undue delay or not? Well, who knows? That's the problem we've got. I think where we are seeing people who are saying, well, our refund credit note period is to the end of March next year, because that's how it works with the financial protection that we have in place. Therefore, we will not pay refunds until 31st of March next year. Those we are certainly saying that doesn't work. That is not paying without undue delay. That is just not paying until 31st of March next year. So I don't think that's justifiable. But there's very much a sort of range between, we will pay you in 14 days and we will pay you in 6 months or whatever. And it's very difficult for us to pinpoint exactly what the right answer is there, but we are certainly having conversations to say to members, you tell your customer when it will be, give him an indication of when they are likely to get their money. And that is going to make the conversation and the process much easier.
Keep that.
So as I say, these are ongoing conversations. If agents particularly have real concerns about particular operators, then obviously let us know, and we will look at that. These are very difficult times, and the enforcement and the monitoring of our code of conduct is difficult at this time, because these are all very, very unprecedented situations that we're seeing.
Yeah. One question we had earlier, actually, and I wanted to make sure we did address it. This is probably more for you, Jo Kay. Question from Angus regarding chargebacks. He says, my acquirers are saying that we don't have a defence to chargebacks, as they view it as failure to supply goods or services. As an agent, we don't hold the money. What will happen if the supplier goes into liquidation? Can we claim on the CAA under the ATOL scheme?
So at the moment, the customer hasn't had a refund at all, or a refund credit note, I assume. There's nothing outstanding at all. They're the agent, right? So I think Simon covered this in his panel session earlier. So basically, as agents, you've got a better defence because you're not the ultimate supplier of the goods. So we are encouraging everyone to defend those claims. I do understand that some card issuers are pushing through claims without giving the merchant the right of reply, and that's really difficult to come back from. There has been some updated Visa and MasterCard guidance on what reasonable alternatives, if they've been offered to customers, whether or not they've tried to resolve it with the customer first. I think all the agents can do is keep pushing it back to the suppliers and try to defend it so it's not coming immediately from them. But unfortunately, because the chargeback process is slightly different to Section 75 Consumer Credit Act protection, it is slightly differently run. So then these chargebacks seem to be happening, and then you get the charge for the chargeback, which means you're paying on top of it. So I am encouraging everybody to keep in touch with their merchant services providers to try and make sure that all of those chargeback requests come to them first, that they have the opportunity to respond. Right. I think, again, it just goes back to the point we're making, that the right of refund remains, and if the customers feel like they're not getting the joy that they want or their response that they want, or at least the comfort, then that chargeback option remains open to them, and that is probably one of the most dangerous things out there at the moment for agents and operators, to be fair.
Right. Okay. Thank you so much to all of you. I'm just keeping an eye on the time, and I know we're running out as ever. It's always against us. I have noted there's quite a few questions in here about furloughed staff. Just to flag to all of you, Joanna, Josie, is on our fantastic coronavirus business support forum. So what I'm going to try and do is make a note of all of those and post those into the forum. So please just keep an eye on that. We'll put a link in the chat so that you can try and see and make sure that all the questions are answered as best we can. Thank you again to our panel. I'm sorry that time is so against us, but we are now going to move to the last session of the day. We have heard a lot about the challenges facing agents, but tour operators have also been facing similar challenges as well, with several winning praise and criticism in recent weeks from the agent community. We've talked with 3 operators about the difficulties they face and how they believe the travel industry will change going forwards.